Now, we are here today to discuss one specific issue regarding medical practice and litigation. But before I do that, there's kind of a broader context that we're here. Since I've been governor, we have worked, when I became governor in 2019, Florida was considered what they termed it a judicial hellhole. And part of that is because we had an activist judiciary, which really wreaked havoc in this state for many, many decades across a wide variety of issues. When I became governor, though, there was a 7-member court. It was a 4-3 split in the wrong direction. 3 of the 4, though, had mandatory retirement. So when I got sworn in, they had to leave the court. So I was able to make 3 appointments, and we've really transformed the court from that activist bastion where good reforms would just be batted down, more on political grounds than anything, into one that's much more predictable in upholding the law. And that's not even true in a medical context. It's true in the business context. It's true in individual freedoms as well. So that really, the Supreme Court change was absolutely huge. And, there have been things that had been passed by voters in the past many decades that court would nullify effectively. And then the legislature would do a lot of things and they would nullify. So those days are over, and that effectively ended judicial activism in the state of Florida just my first month in office. But we also had the fact that Florida was a haven for frivolous litigation. And, there are times when people's rights are at stake, people have been harmed, and they have every right to go into court and to seek compensation. But what happens is that when you have the floodgates open, there's an incentive for lawyers to bring cases knowing that if someone sues you, even if you are 100% in the right, just the cost of having to defend that can be very, very prohibitive. And so a lot of times, if lawyers drive cases, it's cheaper for you to do a settlement, even if you did anything wrong, because taking it all the way to verdict, and if you win 100%, you had to pay all these fees for attorneys and for defense just to be able to effectively show that you weren't in the wrong at all. So that creates a lot of distortions in the economy and medical practice. It imposes costs on our economy and our society. And certainly we've seen things like auto insurance rates and things of that nature driven in large part because Florida had been such a haven for so many litigation and really earned that moniker as being a litigation nightmare. We have done a lot over the years to do really significant litigation reform, and that goes all the way back to 2019 when we curbed the unchecked use of so-called assignment of benefits that allowed third-party contractors to sue insurers directly. That drove up costs and clogged the courts with really a flood of lawsuits. And you think about it, it's like you have a policy, you have a claim, and this becomes like a cottage industry to assign that benefit and this and that clearly got out of hand. So the legislature was able to pass legislation I signed to curb that. We also continued to build off that in 2021 and 2022 with reforms to how property insurance litigation has happened. And basically, Florida was one of a few states that said if somebody sues and they win, then they get attorney's fees. But if they sue and they lose, the other side does not get attorney's fees. Well, that's a major incentive to bring litigation. And so that is not free. That imposed costs. As those costs are put through the system, that helps drive the price that people pay for normal products and the premiums that they pay for that. So that had been something that had been very difficult to do, and yet it's now been a little more than 2 years since those insurance reforms were done, and the results are S&P Global said in 24, the first full year that was in effect, Florida had the lowest increase in property insurance in the entire country out of all 50. Who would have thought that? And the reason is just because you're removing this incentive to litigate even when there really shouldn't be litigation. It makes it less costly. That's why so many people are coming in to do business in Florida. You know, California, they're all leaving for insurance. Like the people that had the fires, they're leaving. Florida, we've had companies moving in since these reforms. Who would have thought that? This is a state that's the most complex insurance market for property in the country, maybe even in the world. We've had 6 major hurricanes in 7 years. I know people in Southwest Florida are very familiar with the last few years in particular, and yet, so far this year, you're basically seeing the rates be stable. You haven't seen them go up 30% like they were prior to these reforms. So that's something that's been meaningful. It has added stability. You have seen more people come into the market. There's just no question that that's the case. Then the following year, 2023, the legislature passed and I signed a broader tort reform and litigation reform, even outside the context of property insurance. And that, I think that's had, people could tell you, small businesses, it's had a positive effect here, but on auto insurance rates. So far this year, the average auto insurance from the major companies is down 4 or 5% in Florida. It's up almost everywhere else, and auto insurance has been the #1 inflationary item across the country over the last 4 years, and the only reason Florida saw a decrease, our drivers aren't getting any better, I can tell you that. It's a tough nut to crack, you know, it just is. But the reason why is because of the litigation reform. I mean, that's the reason why. And you talk to any company, why are they able to offer more affordable rates? Well, it's because we've removed the incentive to litigate first and ask questions later, and that has reduced costs throughout the system. So this has been a lot of heavy lifting. There have been people that have been involved in Florida government and the political scene for like 25 years who've been trying to get legal reform to get us more in line with what works. And, you know, you can see some of these things in different parts of the country. Texas did litigation reform, and they had positive results. Other states, honestly, even states like California have done some that you wouldn't think, but even they have done in certain areas. So that's what you do. Now, for whatever reason, even though all these Republicans in the legislature have voted for these reforms and they've been praised for the reforms, you had a movement in the House of Representatives to undo the tort reforms that have been done and enacted in Florida and that had shown to have produced stability in some of these really, really tricky markets. And it failed in every instance except one, to even advance past the House. The Florida Senate said they wouldn't consider it. I was not going to support what they were doing. Now, the one bill that they did was a bill to undo legal reform and tort reform. Not anything that was done under my tenure, though, something that had been done many decades ago in the early 1990s when Florida was facing a crisis in malpractice insurance premiums and lawsuits that were driving premiums high. Physicians were leaving the state. It really had a bad impact on access to care. So the Florida legislature overhauled how medical malpractice actions are done in these instances of the wrongful death. And what they did was they did something that some states also do. I think it's a minority of states that have Florida right now. I think it may have been some more at the time. But what they basically said is, medical negligence, obviously you have a right to go in and get compensation. If something happens to you, of course, you can do that. But they limited 2 instances to where you could sue for economic damages, but you couldn't sue for so-called non-economic damages. And those 2 classes were if you had an adult child age 25 or older who was not dependent on a parent with no surviving spouse. If you had an action, that 25 or older independent child could sue and get economic damages, but they could not sue for so-called non-economic damages. And the same would apply if a parent was suing on behalf of a 25 or older minor or child, independent child with no surviving spouse or no heirs. You can sue for the economic damages, but not. And the question is, well, why did they do that? And they did it because when you talk about economic damages, those are quantifiable. You can say you were harmed, here's the damage, and you can recover. When you do non-economic, it is basically what a jury wants to award. Now, that's something that's very appealing if you're a plaintiff's attorney, because if you can get a contingency fee out of a big award, you can make millions and millions of dollars potentially on an individual case. So it was the legislature's view that limiting to economic damages would be a deterrent for cases being brought, across kind of in large numbers, right? And so that had been the law in Florida for many decades. What the legislature did this time is they repealed that portion of the medical malpractice reform. And, for me, I think that if we have a right to expect that physicians are going to meet appropriate standards. There's a lot that goes into it. I mean, the state of Florida provides a lot of support for training physicians and everything. And if somebody is careless, and certainly even worse, there needs to be accountability. But I think the question is in a case like this, what's the best way to do that? Is it to open floodgates for non-economic damages, knowing you're going to get a lot of lawsuits that are going to be brought against a lot of physicians who weren't necessarily negligent, right? Because when you're practicing medicine, you can do everything right, and you may not get a good outcome with the patient. There's not a warranty of cure. These are difficult things. Sometimes there's pluses and minuses for what a physician would do. Physician will consult the patient, tell them that here are the options, and sometimes a patient will opt for a course of treatment or a surgery, knowing that there's high odds that it may not be successful. And all these things are very sad, whether the physician was perfect or whether the physician was not. If somebody doesn't make it through that, that is a tragedy in one form or another. And the loss for a family member, even in someone that's an adult and independent at that point, is real. And I think everybody appreciates that. I think the question, though, is what would this legislation do for costs of health care in Florida, access to care in Florida, and our ability to recruit and keep physicians? And I know you're going to hear from people today, but it's their judgment. It's also my judgment that if this legislation would be enacted, it would lead to higher costs for Floridians. It would lead to less access to care for Floridians, and it would make it harder for us to keep, recruit, and maintain physicians in the state of Florida. And we need more as it is now. The state's not shrinking, it's growing, population continues to age. You're going to need more and more there. So what could have been done that would have made this acceptable? Well, I think two things could be done. One is focus on holding the physician directly accountable with regulatory actions. See, you do a malpractice suit, the physician doesn't pay it, it's the insurance company that pays it. So it's not a perfect or even a great deterrent for medical negligence. A third party is paying the costs. We have disciplinary procedures in place, but if there's ways to do that so that folks are held accountable, I'm all for that. The other thing that can be done to prevent this from opening up the floodgates of a lot of litigation is put caps on the damages. If you want to do non-economic damages, put caps on the amount of damages and cap the amount that attorneys can recover. If you do that, then you are totally disincentivizing frivolous lawsuits, because they'll know there's a limited amount that an attorney is going to be able to recover. And if you think about it, if you have no caps on the non-economic damages, that is an incentive to bring a lot of cases, and many of them probably won't be successful, but even then you can probably get a settlement. Again, even if you haven't done anything wrong, there's going to be an incentive to settle, because it's very costly to go through with all this. And then, of course, if you can get a jury to do a big verdict, then the lawyer's going to get a lot of the money there. And sometimes, they're getting 35% of what would be awarded to an individual client or in this case, one of the relatives. So that will incentivize more lawsuits. I'm very much convinced of that. So I told the legislature this going by, and I know they did try to do a cap on the non-economic damages. So they're opening that up, but capping it, and then also limiting the amount that attorneys can recover. If you did that, I don't think you would see a major impact on the healthcare delivery system. I don't think you'd see a major impact on malpractice insurance rates, and I don't think you would see a major impact on access to care. But the legislature did this years ago for a reason, because they were responding to something that was spiraling out of control, and I don't think that what they've proposed here is going to put us on the strong foot without these additional safeguards. So for that reason, I'm announcing that we will be vetoing that legislation. I have been in contact with some of the legislators, particularly in the Senate. I think the change to do the caps failed by one vote in the Florida Senate, and it was something that was, there's some people that don't want to change this at all, but I think of those people, that's something you can live with if you have some caps on it. So if you look around the country, Florida is a minority that says no recovery in these limited instances for non-economic damages, but the vast majority of state have caps on what can be recovered in terms of non-economic damages. And if you don't have those caps, then you really are incentivizing a lot more litigation to take place in the state of Florida. None of that is free lunch. Somebody will have to pay for it. And unfortunately, I think if this bill became law, I do think the cost would be borne by the physicians who would potentially flee the state, to people that wouldn't have as much access to care, and then also to the cost that would go up as a result of it. And we consulted a lot of folks that are involved in the healthcare sector, and I think it was pretty much unanimous that the way this current bill was structured would not have a positive impact on healthcare in Florida, and could potentially have some really significant negative impacts. So I want to appreciate everybody that provided their feedback on this. They were one vote away from doing something that I think was a little bit more palpable for a lot of folks, but it just didn't end up working out that way. So